The law says, bailiffs must give vulnerable debtors adequate opportunity to get assistance and advice before removing goods, otherwise the enforcement stage fees are not recoverable. That doesn't sound much, does it? That leads to bailiff companies making wide and exaggerated interpretations on what they think the law says, or what they want the law to say about the treatment of vulnerable people. We also look at the statutory and guideline definition of a vulnerable person. In this video, we look at how vulnerable people are protected from bailiffs, to what extent, and how to make sure bailiffs comply with the rules on dealing with vulnerable debtors. Enforcement regulations do not give a statutory definition of a vulnerable debtor, but guidelines do, and any guidelines published by a government department are legally binding, provided the law is otherwise silent. The definition of a vulnerable debtor was published by the Ministry of Justice in 2014, in a document called The Taking Control of Goods. National Standards, and at paragraph 77, it states:
the elderly, people with a disability, the seriously ill, the recently bereaved, single-parent families, pregnant women, unemployed people, and those who have obvious difficulty in understanding, speaking or reading English.
The law also provides a definition of disability. The Disability Discrimination Act, 1995 says,
an impairment which has a substantial and long-term adverse effect on his ability to carry out normal day-to-day activities.
Subsection 2 also says,
disabled person means a person who has a disability.
Section 6 subparagraph 1 of the Equality Act, 2010, says,
a person has a disability if he has a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on his ability to carry out normal day-to-day activities.
Paragraph 76 of the Taking Control of Goods. National Standards, published by the Ministry of Justice in 2014, says,
enforcement agents should be aware that vulnerability may not be immediately obvious.
That means, bailiffs must have the necessary training that vulnerable people might have symptoms that might not be visible. Children are also vulnerable people. A child, who appears to be under 16, is vulnerable. Bailiffs are told to leave the property if the only person at home is a person under the age of 16, but the bailiff is allowed to ask the child when the debtor will be home. Paragraph 72 of the Taking Control of Goods. National Standards, published by the Ministry of Justice in 2014, says,
enforcement agents must withdraw from domestic premises if the only person present is, or appears to be, under the age of 16 or is deemed to be vulnerable by the enforcement agent. They can ask when the debtor will be home, if appropriate.
Paragraph 73 gives bailiffs further guidelines if they find an unaccompanied person under 12 at the property, and must leave immediately. It says,
enforcement agents must withdraw without making inquiries if the only persons at home are children who appear to be under the age of 12.
Paragraph 70 further requires bailiff companies to ensure their bailiffs receive the proper training on identifying vulnerable debtors, so they get the proper protection. If the bailiff is unsure whether a debtor is a vulnerable person, then he must seek advice immediately. It says,
enforcement agent, agencies and creditors must recognize that they each have a role in ensuring that the vulnerable and socially excluded are protected, and that the recovery process includes procedures agreed between the agent, his agency and creditor about how such situations should be dealt with. The appropriate use of discretion is essential in every case, and no amount of guidance could cover every situation. Therefore, the agent has a duty to contact the creditor and report the circumstances in situations where there is evidence of a potential cause for concern.
Paragraph 71 continues by saying,
if necessary, the enforcement agent will advise the creditor if further action is appropriate. The exercise of appropriate discretion is needed, not only to protect the debtor, but also the enforcement agent, who should avoid taking action which could lead to accusations of inappropriate behavior. There is no reason why a bailiff should not be aware of these rules, because bailiff companies must be sure their bailiffs have the proper training. In any case, it is illegal for bailiffs to take any enforcement steps against any debtor that is under the age of 16. The law is Regulation 10 sub-paragraph 1a of the Taking Control of Goods Regulations, 2013, which says, circumstances in which the enforcement agent may not take control of goods. The enforcement agent may not take control of goods of the debtor where the debtor is a child.
The regulations give a statutory definition of a child, at Regulation 2 of the Taking Control of Goods Regulations, 2013, which says,
in these regulations, child means a person under the age of 16.
So, there we have the legal definitions of a vulnerable debtor. Bailiffs, before they are allowed on the street, should have proper training about the guidelines for dealing with vulnerable debtors, and bailiff companies give them an operations manual. If a bailiff exploits a vulnerable debtor, then the debtor may apply to the court for damages, and bailiffs have no excuse if they are found to have abused their position, or exploited a vulnerable person to make a gain for himself or another. Now we have established what a vulnerable debtor actually is, we now look at the debtor's rights, and the level of protection they get from bailiffs. You, or your solicitor, needs to be aware of these rules. When you bring a claim for damages as a vulnerable debtor, when a bailiff takes control of your goods, or, in certain circumstances, charged you a fee which the regulations do not allow. The law is Regulation 12 of the Taking Control of Goods, Fees, Regulations, 2014, which says,
recovery of fees from vulnerable debtors. Where the debtor is a vulnerable person, the fee or fees due for the enforcement stage, or, where Regulation 6 applies, the first and second enforcement stages is appropriate, and any disbursements related to that stage, or stages, are not recoverable unless the enforcement agent has, before proceeding to remove goods which have been taken into control, given the debtor an adequate opportunity to get assistance and advice in relation to the exercise of the enforcement power.
That is as clear as mud. So, let's break that down into its component parts. It said that enforcement stage fees are not recoverable unless the bailiff has given the debtor an opportunity to get advice. The enforcement stage fees it mentioned are the statutory fees a bailiff may recover from debtors. But, for these circumstances, it is not important how much those fees are. What's important is the bailiff may not recover them from vulnerable debtors unless the debtor has been given an opportunity to get advice. That means the bailiff must leave the vulnerable debtor for a period of time to allow the debtor to get that advice. Otherwise, if the bailiff does not give the vulnerable debtor an adequate opportunity to get advice, then the debtor is not liable for the enforcement stage fees, and he can apply to the court to recover them in what is called a detailed assessment hearing under Civil Procedure Rule 84.16, at which, under Part D, it says,
disputes about the amount of fees or disbursements recoverable under the fees regulations. This rule applies where evidence that the fee due and any disbursements for the enforcement stage, first enforcement stage, or first and second enforcement stage, as appropriate, are not recoverable under Regulation 12 of the Fees Regulations.
And, just to remind you, Regulations 12 of the Fees Regulations says,
recovery of fees from vulnerable debtors. Where the debtor is a vulnerable person, the fee or fees due for the enforcement stage, or, where Regulation 6 applies, the first and second enforcement stages is appropriate, and any disbursements related to that stage, or stages, are not recoverable unless the enforcement agent has, before proceeding to remove goods which have been taken into control, given the debtor an adequate opportunity to get assistance and advice in relation to the exercise of the enforcement power.
Your solicitor will prepare the application, and must show evidence that the debtor is a vulnerable person. By example, this can be a doctor's letter, proof of disability, proof of receiving of out-of-work benefit. The elderly are a class of vulnerable people, and there does not need to be any evidence the elderly debtor has a disability. Only evidence of their age. Likewise, an unemployed person is a class of vulnerable debtor, but he does not need to be claiming benefit, because claiming benefit is not a condition specified in the guidelines that makes a person unemployed. When you make an application for the return of the enforcement stage fees, your solicitor must decide with care how your claim is presented to the court, and it is not for bailiff companies to dictate what evidence is allowed and what is not. When your application for a detailed assessment is allowed, the solicitor will ask for your costs. If you are suffering from mental health issues, then approach your doctor straight away. They can write a simple note, which you can give to the counsel or creditor, asking them to stop the enforcement. If your health is suffering because of the enforcement, then you must act quickly, and get your doctor to intervene, by writing to the creditor or counsel to withdraw the bailiffs. Bailiffs must handle debtors with mental health conditions with great care. Otherwise, if the debtor's mental condition deteriorates because of the bailiff, or his behavior, he could be liable for a personal injury claim, and that will cost them many thousands of pounds. If you have a bailiff due to call on you, then do not get into an argument with him. They will mess you about. Instead, give the creditor, or counsel who is instructing him, a written notice, telling them that you are a vulnerable debtor. The notice only needs to state your name and address, and give evidence that you are in a class of vulnerable debtor. The creditor, or counsel ought to suspend the enforcement. Bailiff companies have a contractually agreed contract with local councils, called an enforcement services contract. It says bailiff companies must suspend enforcement for 30 days if they find out that a debtor is a vulnerable person. You may still get a letter from the bailiff company. It might tell you that your case has been given to what they call their welfare department. The expression, welfare department, is a bailiff industry buzzword for not attending on the vulnerable debtor for a period of 30 days, or a moratorium on the enforcement for a period of 30 days. This doesn't get you off the hook for the debt, but it does get the bailiffs and their fees off your back for now. Those fees are currently £310. You can use this 30 days to get advice about the enforcement power. Which means, you now have the opportunity to apply to get the enforcement power stopped, or get the debt, either written off or cancelled. I hope you have learned something new today. If you have, please share this video. Until then, if in doubt, keep him out. Procedures for disputing a debt are different, and depends on the type of debt being enforced by the bailiff. The debt can be council tax, a magistrate's court fine, a traffic contravention debt, and a high court writ. We have a separate video for each of these debts, showing you how to stop the enforcement power, or cancel the liability altogether. Once the liability ceases to be exercisable, then the bailiff cannot return. That is because paragraph 6(3) of Schedule 12 of the Tribunals, Courts and Enforcement Act, 2007, says, "The property in all goods ceases to be bound when the power ceases to be exercisable." So, if the creditor or counsel stops the bailiffs, the enforcement power ceases to be exercisable. Dealing with bailiffs has a free online interactive checklist for each of these debts, and shows you what action you can take to stop the enforcement. Remember, you only have 30 days, so you need to get the creditor or counsel to stop the enforcement before those 30 days are up. Otherwise, the suspension of the enforcement is lifted, and you are, once again, liable for the bailiff's fees. I hope you have learned something new today, and if you have, then why not share this video? Until then, if in doubt, keep him out.